Members, we have attained a quorum, and I'll call to order the Bills Committee on Apology Bill. Shall we invite the administration in, please? Members, at the last meeting, we have already embarked on the clause-by-clause scrutiny, and we are done with clauses 1 to 3 of the Chinese version. We're just starting with clause 4 at the last meeting, so we pick up where we left off last time on clause 4. At the last meeting, members agreed that we will be issuing a notice to members, i.e. members of, not on this Bills Committee, letting them know that the Legislative Council proceedings will be taken out of the context of this bill, and this notice has been issued to all eligible members. The Secretariat has already done that. So shall we invite the administration to pick up where we left off? That's clause number 4, please. Chairman, thank you. Clause number 4 provides for the meaning of apology. An apology made by a person in connection with a matter means an expression of a person's regret, sympathy, or benevolence in connection with the matter, and includes, for example, for an expression that the person is sorry about the matter. The expression may be oral, written, or by conduct. Yes, Dr. N. Zhang and Mr. Dennis Kwok. You've raised your hands. Do you have any comments on this part? Dr. N. Zhang and then Mr. Kwok. Subclause 3A, an express or implied admission of the person's fault or liability in connection with the matter. Express admission is very, very clear. Implied admission, what does it mean? Can you cite an example, please? Yes, please. Administration. Implied admission would depend on the situation, but generally speaking, it would like a person who bowed in the circumstance, and as an expression of apology, or someone may have said sorry, and this sorry could be interpreted as implied admission. It all depends on the circumstances. Dr. Zhang, Chairman. I think we have to spell that out here. Implied admission. If someone bows, then it would be taken as an admission of liability or fault. Then it would be hard to judge, isn't it? the implied admission if someone bows and is regarded as admitting the fault or liability, and this is not sufficiently clear. Yes, administration. So can you explain a little bit further regarding the liability and fault? Chairman, clause 4 means that when it comes to the word apology, what does it mean? We're not saying that as long as someone has done a certain act or said some words, then it would be tantamount to admitting liability, and that's not what it means. It's just that we are providing certain safeguards for the apology maker, and that would include the 3 elements: an expression of regret, or an express or implied admission of the person's fault or liability, or a statement of fact. Now, this is the protection, the safeguard that is provided in the bill. Dr. N. Cheung, are you happy with the reply? Or any other questions? Yes, I like to listen to other members first. Mr. Dennis Kwok, Chairman, I'm not sure whether this is the right time to make my comments on the CSA. And Mr. Kwok, at the last meeting, and the CSA on A2, that's regarding the discretion. We did have quite a lot of discussion, and we said that we better start with the clause-by-clause scrutiny first. By the time we reach A2, that can be discussed in greater detail at a later date. Mr. Kwok, A2 is important. Let me say something here to start with. Yes, please make it quick. We are doing clause by clause now. Mr. Kwok, Chairman, now for the CSA provided by the government, this is the best starting point, because from the legal point of view, from the public interest point of view, and also from the point of view of administration of justice, there is discretion allowed to take statement of fact as one of the evidence for consideration. 2A, I think, has struck a balance between the legal fine points. So from a legal point of view, I find this acceptable for 2A, but for 2B, any other relevant circumstances, this is a little bit repetitive. So I think 2B can be deleted. Any other relevant circumstances where the judge considers public interest or the administration of justice, he or she would have regard to all these circumstances. But 2A is acceptable to me, but 2B is a little bit redundant. All right, 2B. In fact, at the last meeting, Mr. Horace Cheung made similar comments. 2B to him is a little bit repetitive, so he is of the view that 2B can be deleted. All right, point taken. Any other comments? If there are no further comments, I give the floor to the administration. Chairman, if we may move on to Clause 5. Clause 5 provides for the situation that the apology applies. But it doesn't matter when the incident occurred or when the applicable proceedings began, as long as the apology is made on and after the enactment of this bill, then there would be protection there. Dr. N. Cheung, Chairman. I'm not sure whether it is the text or whether it is the grammatical expression. It took me a long time for me to work out the meaning here. Let me say this to you. Clause 5.1. This ordinance applies to an apology made by a person on or after the commencement date of this ordinance in connection with a matter, regardless of whether A, the matter arose, as you can see that it says on or after the commencement date. Let's say 1st of January 2018 is the commencement date, and on or after that date. Now, whether the matter arose before, on, or after that date. Are you talking about before, after, or on that particular date, or what? Right, administration. Can you elaborate a little bit on the apology to which this ordinance applies?
解釋一下，其實咧，嗱，我諗睇翻咧，
Now, looking at clause 5, subclause 5.1 is about the matter or incident that gave rise to the apology, and it says whether the matter occurred before, on, or after the commencement of this bill. And 5.1b says that if someone commenced some proceedings after that date, or on that date, or before that date. So one was about the occurrence of the matter, and the other was about the proceedings arising out of the matter. But why isn't it that you just say on or after? Why also before? Because the objective of the bill is to encourage people to make apology. So long as it's on or after the commencement of the bill, and somebody is encouraged to make an apology. So it doesn't matter when the matter occurred or when the proceedings commenced. So whenever the matter or the proceedings occurred, so long as the apology is made after the commencement, then this bill applies. But if this apology occurred before the commencement, then the bill does not have any effect. Can you repeat, Chairman? Now, this is my understanding. This bill applies whenever, no matter when the matter applies or when the proceedings commenced. It applies so long as the apology occurred after the bill is enacted. It's not retrospective. That's correct. Yes, we usually don't make a bill retrospective. So if the bill was not yet enacted, and if I made an apology, this could not be applied to any, could not be relevant to proceedings after the enactment. Now, if the apology occurred before the enactment, then one is not protected. Most of our bills or ordinances are not retrospective. Because that would cause problems when people find that the bill or ordinance makes them vulnerable with regard to something that occurred before. So you have to be clear. looking at 51A and B, I pondered a long time, and then I guessed roughly at the meaning, because it should be made more clear. Can you make the meaning more clear? Very often the meaning in English is clear, but the meaning in Chinese is maybe subject to further improvement. We note Ms. Chang's comments. Next, Claudia Mo. I agree that 52AB also caused me problems. One has to hear the explanation. So all one needs to say is that there's no retrospective effect. You just say it's applicable so long as the apology occurred after the enactment. I felt that there was some problem with 4.1, and now I see that in Chinese there are 5 meanings of apology. It's 歉意、懊悔、遺憾, and also sympathy and benevolence. But in English there are only 3 terms: regret, sympathy, or benevolence. Is it a matter of translation? The government representative, please. The draftsman, please. We thank the member for the question. Now, on subclause 4.1, we use the terms 歉意、懊悔、遺憾 to correspond to regret in English. We consulted different dictionaries. Now, the word regret has several meanings. So you use English as the basis. This reflects the policy intent of legislation. We try to have a broad coverage of the meaning of apology. So we think 歉意、懊悔 and 遺憾 express our meaning. Regret you translate it as 歉意、懊悔、遺憾. You should make that clear. I thought 遺憾 means sympathy. For sympathy, we use the word 同情. I don't quite think that regret includes sympathy. If you are in the wrong, why would you be sympathetic with the other person? I think it looks very odd. Let me try to explain. Now, very often when someone makes an apology, he or she may not just say sorry. He expresses the apology in different ways. Someone may be concerned that if I say sorry, it might constitute a legal liability. So they might say, I express my 懊悔, I express my 遺憾, and those words might not express liability as succinctly. So this provision is to express apology in its broad sense. So we make it broad in coverage so that we encourage people to make an apology in its broad sense. The legal advisor. Now, on the definition of apology, why does it include sympathy. Now, in Canada and Australia, when they define apology, they also include sympathy besides regret. Ms. Ann Chang, Chairman. Now, since you allow going back to clause 4, I say this. Now, whether the apology is expressed or implied, i.e. in 3a, now admitting the fault or liability. So apology doesn't mean admission of fault or liability. Suppose I bump into you, maybe you bumped into me, but I just try to be courteous and I make an expression of regret first. So it's an express of benevolence or sympathy. Now, would that constitute a admission of liability? Now, apology here doesn't mean that when someone expresses apology, he or she doesn't have to express all three elements. But if you just express being sorry, or you might just say, sorry, it's my mistake, either way you are covered. And even if you include a statement of fact, you are still protected. So it's for the person to decide what his apology includes. So long as his apology includes something covered in Clause 4, he is protected. Ms. Chang, are you satisfied with the answer? Okay. Now, Chairman, may I ask that they do something about subclause 5.1a. It's very confusing, the wording. Can you make that more clear? I understand the content, but it's legislation. Now, even if I let a lawyer read it, he would be a little confused. Maybe you can rework the wording a little bit. Is it possible? I understand. I look at it this way. Usually, for the drafting of legal documents, very often the man on the street may not be legally trained, so it may take him some time. As a lawyer, I have legal background. It's a bit easier. Of course, we hope that the government, when they draft the document, try to make it comprehensible to the layman. But some expressions, no matter how hard you try to simplify it, may be difficult to simplify. But I understand Ms. Chang's point. As most laymen wish, the wording should be as simple as possible. Will the government take note? Yes, we note Ms. Chang's comment. Now, 5.1, this clause, this ordinance applies to an apology made by a person on or after the commencement date of this ordinance in connection with a matter regardless of etc. So if you say a matter, should you say that? Now, in subclause 1, now, if someone makes an apology concerning a matter. Now that matter occurs is occurring for the first time, so we cannot say that matter. So we can only phrase it that way. Please look into it. I think it's confusing. Understood. So let's try to improve on the drafting as much as possible. Legal advisor, on subclause 5.1, it says when the apology is made. Now, if the apology is made outside of Hong Kong, how would you deal with that? Thank you. We thank the legal advisor for his question. Now, if the apology occurs, whether it's within Hong Kong or outside of Hong Kong, we consider whether the apology is cited in applicable proceedings. Now, if the apology is made abroad but the applicable proceedings occur in Hong Kong, or if Hong Kong is chosen as the place of adjudication, then the court or adjudicator in Hong Kong will follow Hong Kong's procedural laws to see what evidence can be accepted as such. Now, so long as it's Hong Kong law that is used to determine whether evidence is accepted, then this bill will apply, no matter where the apology took place. So long as the legal proceedings occur in Hong Kong, Hong Kong is chosen as the place of proceedings, then this clause will apply.
So the most important thing is the procedures and all the applicable proceedings. As long as they fall within the proceedings, it would be okay. It doesn't matter where it is. Legal advisor. In fact, what the government said is consistent with the Canadian situation, so I agree with the administration. Right, so much that much has been clarified. Any further questions? 4 and 5 or 5.2? Administration, please. If I may, Chairman, 5.2 refers to the situation where the safeguards will not apply, like an apology made by a person in a document filed or submitted in applicable proceedings, or an apology made by a person in a testimony submission or summary oral statement given at a hearing of applicable proceedings, or an apology adduced as evidence in applicable proceedings by or with the consent of the person who made it. So under those circumstances, this protection will not apply. Any questions for 5.2? Dr. N. Zhang? Yes, please turn on the mic. Thank you. When apology made by a person in a document filed or submitted in applicable proceedings, what sort of documents are you referring to? In 4.2, the expression may be oral, written, or by conduct. So that's the apology made orally, in writing, or by conduct. But 5.2 says that this ordinance doesn't apply to an apology made in a document filed or submitted in applicable proceedings. Administration, please. Thank you, Chairman. Thank you, Dr. Zhang. Subclause clause number 4 provides for the meaning of apology. Now, what does an apology entail? It includes the expression made orally, in writing, or by conduct. So if something has become an apology, clause 5 provides that even if there is such an apology, there are certain circumstances where this ordinance doesn't offer the protection. Under 3 circumstances, the apology will not be protected. 1, an apology made by a person in a document filed or submitted in applicable proceedings. Now, for certain proceedings, there is a need for documents to be filed with the court, and if someone has written out the apology in the document, then there will not be any protection offered. So there are 2 layers there. The first one is to determine what constitutes an apology. If there is such an apology, and if it appears in a certain document submitted in applicable proceedings, then there will be no protection. Right, let me get a question in here. I think you have to explain further in an applicable proceeding. If someone is making an apology on the spot, then that apology would not be included. Indeed, well, let me put it this way. This is an apology for the purpose of this bill. It's just that this apology will not be given protection. And if he agrees that he would like to introduce this in a legal proceeding, then this will not be protected. Ms. Claudian, I find this a little bit confusing, and the more I listen to this. Now, when you introduce this clause, you said that this is of a voluntary nature. Is there any situation where someone is making the apology involuntarily? Now, maybe he doesn't want to answer the question because you have taken an oath to tell the truth, and you are saying this. And also, clause 8 refers to exceptional circumstances. I am a little bit confused. When will this apply? Right, let me supplement clause 5. We have a member who just come in. We are on clause 5.2. We're doing clause by clause scrutiny. Now, 5.2 says that in applicable proceedings, like in a civil proceeding in court, if someone is making an apology on the spot, then that would not enjoy any protection. If I may put this to the administration here, when you draft this clause number 5, why is it that for the on-the-spot apology in a civil proceeding, why is it that this will not enjoy any protection? Dr. N. Zhang and Ms. Claudia Mo raised similar points a moment ago. Perhaps you might wish to explain a little bit further. Yes, Chairman. Now, in the court proceeding, you have to submit the document, you have to testify, you have to give testimony. Nobody compels you to say anything. It's entirely up to you. Now, after exercising your judgment, having regard to legal advice, decide what to say. So after consideration, if someone were to make to adduce an apology previously made as evidence in court, then he doesn't, in fact, want the protection himself. Yes, my colleague has something to add. Yes, Chairman, if I may add here, why do we have this clause? In absence of this clause, a defendant may be making a response and offer an apology, and without this clause, then the document cannot be submitted. If someone admits liability and wants to make an apology and wants the court to be aware of that, without this clause, then the apology cannot be adduced as evidence. Right, Chairman? Oh, sorry, I am Chairman. Now, I think you are talking about 2C. Now, that's the situation that you cited. But A and B, it seems that there is a bit of difference. Now, you are saying that in the court, in testifying, I think I have to make an apology, and this is an admission of liability. Now, that's 2C, but 2A and B, if someone makes an apology on the spot, it doesn't mean that I am admitting any liability at all. He may be just making apology on the spot. Right? If members may refer to C, C refers to an apology adduced as evidence in applicable proceedings by or with the consent of the person who made it. So it may not be himself who adduces the evidence. Is with his consent that this happens. Maybe someone wants to adduce his apology as evidence, but the apology maker agrees with that. That falls within C. Whereas in A and B refers to the person himself. Documents filed in applicable proceedings. In the document, someone can have the apology in writing. Maybe he wants to adduce this apology. And in B, when someone is giving testimony, submission, or assume an oral statement, and this is an apology made in this kind of testimony or submission. If someone makes an apology in court, then it means that he doesn't need any protection, and he wants to make people aware of his apology. I do have doubts in mind. Some members also raised their hands. I do have some doubts that A and B should be further qualified because a layman reading these clause might have some misunderstanding. I think you have to make it sufficiently clear that for apologies made on a voluntary basis, and agrees that this can be adduced as evidence, I think this should be added to qualify the subclauses. Ms. Eunice Yung, C, Chairman, an apology adduced as evidence by or with the consent of the person who made it. Now, who adduces the apology? I think in 2B or in 2C, an apology adduced as evidence with the consent of the person who made it. Now, who is actually adducing the apology as evidence? Is it the judge or who, or the opposite side? Or can the apology be adduced without the consent of the person who made it? Administration? Yes, let me try and address this in C. The key meaning is the one who adduced the apology as evidence can be the apology maker, or it can be the opposition side, or the one who receives the apology. But if it is adduced by the opposition side, then it has to have the consent of the person who made the apology.
So you just keep the latter half. You don't have to keep the first half. Because if the evidence can be adduced without consent, that's in the first half. And the second half applies to the adducing of the evidence with consent. So you should make that clear. And let me make clear. This bill is to protect the person who made the apology. Here it says that even if the bill offers protection to the person who made the apology, what circumstances are there where he is not afforded the protection? And C says that if the person consents and the other side consents to the apology being provided as evidence, then the ordinance does not protect him. Now, so the apology cannot be adduced unless the person consents. So if he consents, then he is not afforded protection. So you should make clear that the evidence is adduced with the person's consent. I think it should be and, not or. Now, let's say C is resolved, but concerning A and B, for the layman reading this, they might misunderstand that if there is legal proceedings in court, then if he uttered an apology, maybe he didn't want to admit liability, but he uttered the apology anyway. Now, according to 5.1a, then now can you make this more clear? Now, this seems to differ from our understanding in past meetings. Let me make clear. 5.2a and b refer to the person making the apology. Now, he made an apology outside the court proceedings, then the bill protects him in that the apology cannot be cited as evidence. Now supposing the proceedings have commenced and the person wants to refer to the apology during the proceedings, he hopes to adduce that as evidence, then this legislation does not protect him. Now, he's the person who made the apology. The apology was protected. He wants to give up that protection. He wants the decision maker to know that he did make that apology in the applicable proceedings, and he's willing to offer that apology as evidence. Then we don't need to protect him. Kenneth Low? Let's look at 5.2ab. Now, the wording in English. Now, I see that I can understand DOJ's view. Now, I think the subject in 5.2a and b is not very clear. Now, you say that if someone wants to allow the apology to be adduced. Now, whether it's adduced by a third party is not very clear, even if you read the English wording in its entire context. Now, if type 2A and B are different limbs, then C seems a little superfluous. Now, A, B, and C, in my view, now A and B already cover the scenario, but to me it seems strange to add C. I think there is some problem with the drafting. So it seems that members have some problem with this. Legal advisor, now concerning 5.2, I previously corresponded with the administration for quite a while. Now for Mr. Leung's query on whether C is superfluous, my understanding is that A and B deal with apologies made in civil proceedings, for instance in pleadings, or when evidence is provided in court, the apology made there and then. And C refers to apologies made outside of the proceedings, say a letter of apology, even though the apology was made outside of court proceedings, and yet you want to adduce that evidence. You want to adduce that apology as evidence. That's where C applies. Let me supplement. Now, A is about the pleadings or witness statements, the written documents. Now, B refers to verbal evidence or verbal submissions in court when the apology is made. And C, as the legal advisor said, is an apology made outside the proceedings. Now, if the person who made the apology wants to adduce it as evidence, he can. Now, if the other side wants to cite an apology outside by that person outside the court, and so long as the person consents, it can be adduced. So see, there are two parts. First, the person adduces the evidence. Secondly, the apology is adduced as evidence with his consent. Now, Mr. Kenneth Leung, now can you make the drafting for C clear? You say apology made adduces evidence in applicable proceedings by or with the consent of the person. You can say an apology made outside applicable proceedings. Otherwise, it's rather puzzling. Also, it seems that you have to make clear to the public that the apology bill, when proceedings occur, then in the documents that you submit or whatever you say in court, there shouldn't be any apology if you want to be protected. Because according to 5.2ab, then we must remind people that if you utter an apology outside the court proceedings, then you're protected. But if you are in the court, and if you offer certain written evidence, then you shouldn't make any apology because you wouldn't be protected. If that's your meaning, I hope you should make that clear to the public. Otherwise, I worry that the public might misunderstand, just like members now misunderstand you. I hope you take note. Mr. Chung Kwok Pan, thank you. Please turn on the mic for Mr. Chung. Please turn on the mic. Okay, you are now heard. Now, speaking from the layman's perspective, if the legal proceedings occur and before that I haven't made an apology, then under what circumstances would I make an apology within the proceedings? Well, I wouldn't be protected. Under what circumstances would I make such an apology? Otherwise, I would never apologize, right? Now, if I apologize and I'm not protected, then I might be sued. Can you give an example? I don't quite understand. The administration, have you any examples to offer? My colleague will supplement. One example is, supposing the person may not have much to contest about the actual occurrence, and he is sympathetic, and this might be a factor for the court to consider that. Now, and also, say in medical counsel, when the committee considers whether the doctor admits his liability, then these are factors to be considered. So very often the person apologizing wishes his apology to be adduced as evidence. Suppose it's a medical healthcare misconduct, then he was already protected. Why is it that he had to apologize afterwards, after the proceedings occurred? Is it that he knew that he would lose the case, and he hoped that by making an apology he would reduce the sentence? Now, this bill doesn't stipulate when a person should make an apology. He can make an apology at any time. A person may not think it's appropriate to apologize when the matter occurred, but after he obtained legal advice for the legal proceedings, then he thought that an apology might reduce the penalty in the eyes of the court. So he thought that, okay, now it's legal proceedings, I have to try to mitigate for myself and reduce the likely penalty. Then he might choose to utter the apology within some document offered in court. My understanding is that after one admits the liability, then the compensation would be considered. Now, this is very common. For instance, in industrial accidents, very often one doesn't argue about the liability, and then one wants to focus on the compensation. Now, I understand Mr. Chung's question. Now, on 52AB, now this might lead to something strange. Some person very early on might have made an apology, and but because of 52AB, then when he's in court, the lawyer might advise him, okay, your earlier apology is okay, but in court, no matter what pressure you're under, you mustn't utter any word of apology. Now, if that occurs, would that be at loggerheads against the intent of the legislation? Now, if he made an apology early on, the lawyer might tell him, that's okay, but in court you shouldn't indicate any sense of apology. That would be rather strange. Would you think that's possible? Let me try to explain. Now, the bill tries to offer protection in order to encourage people to apologize. So after one apologizes in applicable procedures, you shouldn't lightly cite the apology as evidence. So if person apologize at the outset, and then as the chairperson referred to, after the legal representative advised him, he thinks it's not appropriate for him to apologize. We can't force him to apologize. This is what this clause tries to deal with. A person has considered he doesn't want his apology to be used as evidence. This is the clause that deals with that situation. Whether a legal advisor gave him any advice, he has the right not to cite his earlier apology.
All right, now let's hear from other members. I'm beginning to understand your point of view. Here, in a way, you're encouraging people to make an apology at an early stage. If you make an apology on the spot in the proceeding, then you will not enjoy protection. But if you make the apology earlier on, you do enjoy the protection. You're in a way encouraging people to make an apology maybe ahead of the court proceeding. Because if you do so in a court proceeding, you lose all protection. From your explanation, I'm beginning to understand your intention here. Now let's hear from other members. Chairman, my colleague would like to take the floor. Chairman, if I may, 2A and B. In the absence of 2A and B, there may be a situation where, let's say, a doctor in an inquiry would like to offer an apology in the pleadings. Now, without these 2A and 2B, it's hard for him to do so, because under the ordinance, under the bill, he would enjoy the protection, and he would not be able to let the court know that he would like to make such an apology. Even if he makes an apology on the spot, this cannot be admissible, and this may become a ridiculous situation, so we have to make it sufficiently clear here. Here, like you said, that doctor would like to make a genuine apology. Now, he has already admitted the responsibility, and through this genuine apology, he would like to reduce the compensation. Is my understanding correct? Now, if he goes to the court and he makes the apology, then it would amount to an admission of liability, and he would be able to get a lighter compensation. Let's say a doctor has received a letter to be invited to an inquiry, and he would like to make an apology, and he would like to include the apology in the response. Now, this is on a voluntary basis. Without this clause, then this response or this apology during the testimony cannot be adduced, and this would give rise to a bizarre situation. We'd like to avoid these, and that's why we have these clause here in the bill. Any further comments? Dr. N. Zhang, Chairman. Obviously, I heard from the administration, and basically I understand the bill. I understand when I listen, but when I'm looking at the bill again, I am a little bit confused. So does it mean that the wordings here are not sufficient to articulate what you meant to say? I understand what you had to say verbally. Can the wordings here be tidied up a little bit, or are you better at English than Chinese? But the Chinese is rather difficult to comprehend. Following on from Dr. Ann Zheng's comments, now she's looking at this from the public point of view. I must admit that after this questioning, we are beginning to understand the intention, but from the members of the public's point of view, they may not be able to comprehend when they're reading it. Now, assuming that this will be passed, are you going to have any leaflets to explain the bill? Indeed, Chairman, this is what we are going to do to make the public understand the bill more easily. Or you might wish to include certain scenarios in the pamphlets, because people certainly would have some misunderstanding reading the bill. Yes, most certainly, Chairman. Any further questions on 5, Chairman? We understand the meaning behind it. By the time they have tidied up the clause, like clause number 4 and clause number 5, I see the need for some polishing of the wordings there, because it is rather hard to comprehend. I have lawyers, I'm flanked by lawyers here, and 5(1)(a), and let me put this to the lawyers. I think they might have different interpretation when they are reading this. We are legislators, we are lawmakers, and we have to pass the bill, and if the wordings are not sufficiently clear and they can be open to interpretation, we do have the liability. We support the bill, but I don't think I can accept the wordings here the way they are drafted. All right, administration. I'm sure you've taken note of Dr. Ann Zheng's comments. She raised this point on more than one occasion. Perhaps you might wish to have a look at the wordings and see whether they can be tidied up. Most certainly, Chairman. Yes, Mr. Kenneth Leung, Chairman. This bill has a dozen or so sections or clauses. We have been dwelling on this for a pretty long time. Will the DOJ give us some guidelines? Can you give us some guidelines with regard to the different clauses? The guidelines are not binding, of course, but when the judiciary or when the lawyers are reading this, they can make reference to the guidelines. I can't remember which bill. I'm sure there were bills where they were accompanied by some guidelines when they were issued. I am wondering whether you would break with tradition. There are so many doubts raised by members. Perhaps you might wish to give some guidelines for each and every clause of the bill. Administration, any arrangement like this? Chairman, if you turn to the back of the bill, we do have the explanatory memorandum. We have the meanings of the different clauses included here. Members might wish to have a look at the explanatory memorandum there at the back of the bill. All right, members have already expressed their comments on the drafting of the bill. Myself and Mr. Kenneth Leung have raised the possibility of some guidelines. I know that there is the explanatory memorandum at the back, but I'm talking about some day-to-day examples, some scenarios for people to digest the bill and what this bill is all about. Members have already expressed their views. There are certain clauses that indeed would give rise to misunderstanding, and I hope that you would consider these. Most certainly, Chairman. Unless you have any further comments on 4 and 5, let's move on to clause number 6. Administration, please. Chairman, thank you. Clause number 6 is about the meaning of applicable proceedings and under what circumstances will the protection be available. Now here it is about the civil proceedings, and they include judicial, arbitral, administrative, disciplinary and regulatory proceedings, whether or not conducted under an enactment or other proceedings conducted under an enactment. In other words, in these proceedings, an apology cannot be adduced as evidence. Right, I saw some hands. Dr. N. Chung. This apology bill is applicable to civil proceedings. It is applicable to arbitration, administrative proceedings like hospital authority. Administrative proceedings, can you be more specific? Yes, I defer to my colleague. Chairman, administrative proceedings refer to the administrative appeal board, and this board would adjudicate on the administrative decisions of the executive authorities if someone feels aggrieved and lodges an appeal that would go to the AAB. Now, what else other than the AAB? Now we can think of the administrative appeal board for these kind of proceedings. Dr. N. Chung, can you think of anything else? Well, I've set on AAB, and we deal with the appeals like the licenses of security guards and so on. And I did assist in the drafting of the verdict in Chinese, and people didn't have any clue how it should be drafted. I'd like to find out a bit more. Administrative proceedings are referred to the AAB. I would have thought that the executive authorities include many things. So AAB, I don't think there isn't a lawyer. What about disciplinary proceedings? Administration? I defer to my colleagues. Disciplinary proceedings, like dentists, doctors, subject to disciplinary action, or some professionals, they do have their own associations and they do mete out disciplinary actions. And civil servants, they also have the disciplinary proceedings, and these are what we're referring to. The medical council is a case in point. Yes. A doctor said something to a patient under A2. This can be adduced as evidence. Is that right? Administration. A2, like Chairman said previously, we'll leave this till last, and we will make a response when the time comes. Would they be affected by the outcome of A2? Simply put, for the medical council, this is an applicable proceeding, so the apology will enjoy protection in that context. Dr. N. Chung, A whether or not conducted under an enactment. B. Other proceedings conducted under an enactment. 6(1)(a) and B. Should it be under an enactment, or should it not be under an enactment, or does it really matter? Administration. There are two sides to this. For judicial, arbitral, administrative, disciplinary, and regulatory proceedings, whether there is any ordinance governing them, this apology bill would apply to these proceedings. There are certain situations where there are provisions under the law, there are certain proceedings in that category, and the apology ordinance will still apply. Dr. An Cheung. Now for this apology bill, now this applies to civil proceedings. If this is the case, I think this is all the more reason why we have to make it sufficiently clear here.
Okay.
Well, civil proceedings, so you should make the wording even more clear. There are too many arguable points. People have lots of arguments. I'm concerned. Am I over concerned? Should I stop? I think your queries are reasonable. This affects many people. They affect the people on the street. So that's why I go word by word. The legal advisor, there was an An Cheng's question concerning 6(1)(a). The following proceedings are applicable, whether it's under enactment or not. Now, I clarified it with the administration earlier on. Now, whether the proceedings are judicial, arbitral, etc. Now, even if it's under the tourism board, now they are covered. Those proceedings are covered. So the tourism board, etc. Now you're talking about disciplinary proceedings. So, what disciplinary proceedings? Perhaps you can make clear what that category includes. For instance, the ACCA, is that covered in its proceedings? Ms. Chang's question is, have you considered listing all the applicable proceedings in a table? Now, I don't know whether this has been past practice in law drafting, and the chambers of commerce, are those included? Suppose the General Chamber of Commerce, you are talking about the proceedings within the Chamber of Commerce. I don't know. Kenneth Leung? Perhaps I will assist Ms. Chang. Now, on the definition of applicable proceedings, judicial, administrative, etc. Now, chambers of commerce have members, right? Members join, right? That's why I need to know disciplinary proceedings. Which organizations have disciplinary proceedings? Now, so long as there is a hearing, a system of hearings that sanctions the members, So are these administrative? Or you refer to certain legislation, statutory organizations set up under those laws, or the administrative and disciplinary proceedings under those ordinances. Now, the chambers of commerce, they are private organizations. They are not statutory, right? Now, on whether all the proceedings can be listed in a table, I think it may be difficult. First, we are concerned whether we leave out an odd one here or there. Secondly, at different times, there may be people who feel that they want to establish some new proceedings. Now, if we don't include that organization, then later we might have to amend the legislation very frequently. So that may not be something we wish to see. And here we also explain why we express 61A in certain categories of proceedings. If you fall under those categories of proceedings, then it applies. Now, if the chambers of commerce have certain hearings, then those disciplinary proceedings, provided they are disciplinary in nature, would fall under this clause. So you have to make clear, suppose a man on the street wishes to sue the administrator of a public market, will that apply? Now, if that member of the public wants to sue the administrator in court, then if it's in the court, then it's 6-1. Now, if he wants to complain against the caretaker and there is disciplinary proceedings, then also that applies. So whether it's private organization or public organization, so long as it's an internal disciplinary proceeding, then this clause will apply. Understand? Concerning clause 6, any more comment? Claudia Mo? I'd like to ask about 61A again. It mentioned disciplinary proceedings. Now, last time it's mentioned that in Legislative Council there are disciplinary proceedings too. That was already discussed. You said there would be a CSA. Yes, there would be. Okay, that's my only point. No problem. Any other questions about clause 6? If not, let's go to clause 7. Now, 6.2 says applicable proceedings do not include criminal proceedings or proceedings specified in the schedule. And it's been mentioned that this doesn't apply to criminal proceedings. So how about the schedule? Now, in the schedule, there are 3 proceedings which to which these provisions do not apply. That includes the proceedings conducted under the Commission of Inquiry Ordinance, Cap 86, proceedings conducted under the Control of Obscene and Indecent Articles Ordinance, Cap 390, and proceedings conducted under the Coroner's Ordinance, Cap 504. Legal advisor? Now, the Commissions of Inquiry Ordinance, now, I noticed that in subsidiary legislation B of Cap 448, in section 18, it gives the CE the power in respect of certain aviation incidents. He can appoint an inquiry committee to study the accident. So it's called Commission of Inquiry. Now, the Rule 4 says this is to study the cause of accident rather than to assign responsibility. Now, Cap 448 proceedings may be similar to Cap 86 proceedings. So should Cap 448 proceedings be included in the Schedule 2? We thank the legal advisor for his question. Now, when we prepared this bill, we went through a broad consultation within the government, and in 2012 and 2016 we undertook public consultations, and they were within the government consultations with the policy bureaus and departments. We haven't received any comment from the Civil Aviation Department that they want their proceedings to be placed in the schedule. Of course, the schedule can be amended. It can be amended by subsidiary legislation. If any proceedings are considered by the relevant bureau or department to be appropriate for this schedule, we can consider that. Thank you. Kenneth Leung. I also would like the administration to explain about the 3 pieces of legislation covered in the schedule. The 3 pieces of legislation are very different in nature. Why is it that the proceedings under these 3 pieces are placed in this schedule? They are completely unrelated proceedings or laws. So maybe there was already an explanation, but could you explain why were these 3 pieces of legislation selected? We thank the member for his question. Now, in earlier public consultation, we discussed this matter. Now, at first appearance, the 3 are not related, but the main thing is that they do not try to determine who is legally liable. They are mainly to find out what had occurred. So we think that the purpose of the apology bill doesn't quite apply, because we were trying to attain a resolution of the matter without legal proceedings. Now, so the purpose of these 3 pieces of legislation are quite different. Why is it that these 3 ordinances were selected? It's because the proceedings thereunder do not target a person or group of persons to determine their legal and liability. It's just to find out about the facts. Is that what it means? Yes, no problem. Claudia Mo? I still have a query. Now, for laymen, when they look at this, it seems a bit arbitrary why you chose these 3 sets of proceedings and make an exception of them. Now, first, are there ones that you missed? And secondly, the legal advisor had a query about Cap 448B concerning civil aviation. You said that the CAD didn't raise the need, but this is drafting of a piece of law. You think there's absolutely no need? we thank Ms. Mo for her question. Now, actually, we considered this issue internally, but because we are unable to have a full grasp of the internal procedures of every department, so we work through an internal consultation mechanism, asking them whether they wish their internal proceedings to be placed in this schedule. So we leave it to the individual department or bureau to decide, because they do not provide us with all the detailed information. So they were aware of the bill, they studied it, and they thought that there was no need. So up to now we haven't heard from departments like the CAD saying that they want to be included. If in future we hear otherwise, we can amend the schedule.
Beg your pardon, Ms. Claudian, my question is similar to yours. I've got a question. Well, this is my time, Chairman. Yes, go ahead. Sorry, beg your pardon. Go ahead. All right, okay, sorry. Well, the Chairman should not barge in like this. Yes, go ahead, please. Sorry? It's all right. Please. Thank you. Thanks very much. I don't need your help. The legal advisor mentioned the Commission of Inquiry, and you said that it would be hard for you to be exhaustive. In your schedule, you have the Control of Obscene and Indecent Articles Ordinance, the Coroner's Ordinance, and you said that when necessary, further ordinances can be added. Now, in future, you might have all these requests for addition. I think you can do away with the schedule, and you can say in the bill that if it is fact-finding inquiries, then it doesn't apply. It would be far safer for you to be so exhaustive about the 3 ordinances, but the legal advisor highlighted another piece, and you said you didn't see the need for that for the time being. Administration. Thanks very much, Ms. Claudia Mo. If we do this in a prescriptive manner, this may give rise to some doubts. There may be some uncertainty whether there is a scenario which may or may not apply. We did mount a consultation in 2015 and 2016, and we had an internal consultation mechanism, so we have trust in the policy bureaus that they have already conducted some assessment. Like Ms. Mo said, you've got a point there. In future, there may be requests that after some consideration, certain ordinance should be included. There is such a possibility, and we do have the mechanism to deal with this, although we don't really want to constantly ask the Council to do it all the time. Now, at an appropriate time, if there is such a need, we will present this to the Council. Ms. Mo? So you're convinced that you have not missed out on anything, and for these 3, this is as much as you can include? Yes, from our information, it is our assessment that these 3 should be included. Administration, let me raise some doubts here, and I hope that we are using the same standard. It was requested that all the proceedings, applicable proceedings, should be tabulated, and the administration said they don't really want to do it because they might miss out on something. Now, for proceedings that are not applicable proceedings, and I get a feeling that there are quite a lot in this category. Other than these three in the schedule, I'm sure that there would be others, like the one cited by the legal advisor just a moment ago. Now, if we apply the same criterion, should we have a schedule including the proceedings that are not applicable proceedings, or should we say that if the criteria, if they do not fit the criteria, then they are not applicable proceedings? It would be far better than having a schedule here. Administration? Yes, the purpose of the bill is to encourage making apologies. When we talk about applicable proceedings, we would like to include the civil proceedings as much as possible. If we want to include the applicable proceedings extensively, it would be hard for us to have a table, because if we miss out on one, then it will not be good enough. Now, here in the schedule, they are not applicable proceedings. So what we want to do is to apply the bill to the civil proceedings as far as possible. It's only in certain scenarios where the policy bureaus or the departments consider that this should not apply. This is the way we adopt to highlight the not applicable proceedings. Dr. Encho? Chairman, why only these three that are not applicable proceedings? You must have your points why they are not applicable proceedings. Last time we asked you about the electrical proceedings, and after consideration you said no, they're not applicable proceedings. Now, our legal advisor has highlighted some hearings that should be considered as not applicable proceedings. Can you be more specific about these proceedings that are not applicable proceedings? Number 8, decision maker. It is rather strange. It can be a court, a tribunal, an arbitrator, or any other body or individual. Now you make it very, very specific here. Decision making in clause number 8. Decision maker. Whether a court, a tribunal, an arbitrator, or any other body or individual, an individual can exercise the discretion. Chairman, well, let them tidy up the whole thing, will they? We're on clause number 6, and let's sort out the schedule, the proceedings that are not applicable proceedings. Should we have the list, or why we include those three? Let's focus our attention on this. Clause number 8, we're going to be moving on to this later on. Let's get number 6 out of the way first. Any further comments? Administration? Okay, to respond? Basically, you would adopt the existing drafting proceedings that are not applicable proceedings. You don't rule out the possibility that there may be further proceedings that will be included in the schedule. Indeed, Chairman. Unless there are further questions on number 6, let's proceed to number 7. Administration, please. Chairman, number 7 is about the effect of apology for purposes of applicable proceedings. If an apology has been made by a person in connection with a matter, then the apology doesn't constitute an express or implied admission of fault or liability, and the apology must not be taken into account in determining fault, liability, or any other issue in connection with the matter to the prejudice of the person. Comments? Dr. N. Chung, Chairman. I have to say this, Chairman. The minutes will duly record our remarks. Clause number 7, effect of apology for purposes of applicable proceedings. For the purposes of applicable proceedings, an apology made by a person in connection with a matter does not constitute an express or implied admission of the person's fault or liability. But in clause 4, the meaning of apology 3a refers to an express or implied admission of the person's fault or liability in connection with the matter. So this should be included, shouldn't it? Is it contradictory? Chairman, you are a smarter person. Can you tell us what it means? Right, administration, please. Chairman, if I may. Clause number 4, within the meaning of this bill, what apology includes. And this includes, like Dr. N. Chung said, an express or implied admission of fault or liability. Whether the apology maker has made any express or implied apology that would be interpreted as an admission of liability or fault. That is included in the meaning of apology. With this meaning, then we can move on to look at clause number 7. Clause number 7 provides that whether you have done certain things that can be interpreted as an admission of fault or liability. Now, for the purposes of applicable proceedings, an apology made by the person does not constitute an implied or express admission of fault or liability. So it doesn't matter what is in the apology. One cannot take the apology and say that the apology maker has admitted fault or liability. In other words, you may express sorrow, regret, or sympathy in your apology. It will not be taken to mean that you have admitted fault or liability. This is a simple explanation of what it means. Dr. N. Chung, any further comments? I heard that, Chairman. Legal Advisor? Chairman. 7.1b. An apology must not be taken into account in determining fault, liability, or any other issue in connection with matter to the prejudice of the person. In the explanatory memorandum number 8, it refers to the sanctions remedy and credibility. So all these are also related. Remedies, sanctions, and issues of credibility. All right, thanks very much, Legal Advisor. Unless you have any further comments, then let's move on to Clause 8. Let me put these to members here. When we started the clause-by-clause scrutiny, we all understood that clause number 8 is rather controversial, and we would need more time, and we agreed that we should start the clause-by-clause scrutiny. We should save number 8 till last. Do you agree We have only 9 to 13 left that have not been looked at. And shall we get these out of the way before we come back to clause number 8? Mr. Michael Tin. I've been waiting for number 8. How long are you here till? I'm not sure how long you will need for 9 to 13. Mr. Tin, we're here till 6:30. I've got comments to make on number 8. Mr. Tin, you might wish to take the floor first regarding number 8. Yes, go ahead, please. For those in front of the television, you may not know what I'm talking about. Please turn on the mic for Mr. Tin. As a public figure, I think I am an apology expert. In the KCRC, I was famous for sticking my neck out and making apologies for inconvenience caused. And the company was very concerned, and they tried to stop me making an apology. They tried to stop me saying more than is necessary.
Now, my experience at the time I will now share with you, but first I'd like to tell you, for you to judge whether this is the current situation. The current situation is that an apology is not protected. If you say I'm sorry, you might be vulnerable. And situation 2 is you protect apology and you don't protect anything else. 3 is 8.5. Now, if there are some statements of fact that are protected, situation 4, 8.2 AB. Now, the protection is wider. Situation 5 is 8.2A. That's protection is wider, and finally, any statement of fact is protected. Now, I'm speaking from personal experience. Today, we must have apology legislation. So, 1, I do not accept. To me, 2, 3, 4, and 5. For a conservative person, he cannot make the distinction. What is public interest, etc. Now, he wouldn't take risk. So a careful person would, one, like me previously, sorry, I apologize for the inconvenience caused to you. I'd like to share with you, back then, I made very many people pacified. Now, 4 hours, there was no fine, and the company chairman should show up and make some kind of indication. So somebody comes out, makes a bow, or just say sorry. I think that's effective. I don't agree with many people who say that if you just say sorry, then you are not sincere. Then apology is worse than making no apology. I don't agree, so I don't accept situation 1. I hope that there can be apology legislation. Now, as for apology bill, situation 2, 3, 4, 5, I think a conservative person would just say sorry and wouldn't say anything else. But for me, that's enough. So, after thinking for a long time, I support this bill. And so you are no longer thinking about 2. So if you don't agree with 2A, now if you go closer to this side, you might go against the Constitution. You want to reduce the chance of infringing the Constitution to a minimum. Is it 8.2A or is it you want to add B? I'd like to ask. Government representative? we thank Mr. Tian for being very careful in his analysis. If you ask about the government's stance, I think we have 8.2 AB. That's the most reassuring. We think that reduces to a minimum the risk of infringing the Constitution. Now, we think that having 8.2A and B, that would be safe. Initially, it's 8.2. It's because of our comments that you have 8.2A and B. Now, the minimum risk would be 2, right? Yes, but after all the meetings, we have heard many different members' views, so willing to make some amendments. So you take a little risk. So we think that an acceptable risk is the 8.2A and B. Now, if you don't have B, if you just have A, then you think there's some risk. Yes, in that case, I understand. For me, 8.2AB, 8.2A, either of those I accept. What I don't like is what we have today. I think just saying sorry is helpful. Dennis Kwok? Just now at the opening, I commented on 8.2. My view is similar to that of Mr. Tian's. I think 8.2A is already striking the right balance and it's the safe approach. And I think the risk of a legal challenge is reduced to the minimum, because 8.2A, when the court has to consider public interest and justice, administration of justice, then the court has already considered all the relevant circumstances, so that's already included in 8.2A. So I think if you just have 8.2A without 8.2B, I think it's acceptable, and the legal risk is reduced to a minimum. And you can read the provisions more closely, because public interest and the administration of justice, that already includes many factors already. Next, Kenneth Leung. I express similar view, because I think 8.2A is already very broad in its coverage of all the factors. If you include B, any other relevant circumstances, then some layman may query, now what is a relevant circumstance? Now, perhaps Ms. Ann Chang would query what B refers to. Now, a simpler way, a more streamlined way, and a drafting mode that is more understandable to the users, then I think 8.2A by itself will already resolve the problem. Of course, you might have done some other risk assessment. Previously, you felt that even without A and B it would suffice, and now we think that A alone is sufficient. Would the government accept the views of the committee? Mr. Ho Kwan Yew, concerning this CSA 8.2AB, which are added provisions, I welcome that. Earlier it's been mentioned that in clause 10 it has to be clarified whether it's A2 or now with A2AB, which is clearer, it would not affect the liability in respect of insurance. So earlier Ada already explained that, and already explained the explanation, and I think the legislative intent is already made clear. So whether the statement of fact is determined by the decision maker. Now 8.2a b already clearly clarifies that, so the insurance industry is not affected. Originally I wanted to add something, but now I think there's no need. Thank you. Any other member with views? Ann Chang, any view? Are we talking about Clause 8? Yes. Earlier we thought that when it comes to clause-by-clause scrutiny, we would go through all the other non-contentious provisions first. However, the other speakers want to speak about 8 too, and I let them. So, Chairman, now I've sat through many bills committees, and I am quite agreeable provided they are broadly acceptable. Now actually I often take a broad brush approach, but still I think the apology bill is rather crude or lack polish. Now 8.2. Now if in particular applicable proceedings there is an exceptional case, the decision maker may exercise their discretion. Now I don't quite understand that. If there is exceptional situation, now you say there's no other evidence, then why do you you just say there's no other evidence, and then why do you imply that there are other possible cases? Now, if there is no other evidence, then very often you wouldn't go and sue someone, most likely. Then why do you now, if you now say you sue someone, someone said an apology to you, uttered an apology to you, and then you ask the court to exercise discretion to rely on that apology, then it would be very contentious in court. So all the lawyers shouldn't be able to speak on this matter, because you have to declare interest. This is about civil proceedings. The public are the persons affected by these civil proceedings. Now, if you sue someone, now you can cite an apology made on a certain day. Now, if you are a legislative counsellor, you have to be accountable to the public. Now, who is the decision maker? First, we say it's the judge, but now the decision maker can be the court, tribunal, arbitrator, or any other body, or even individual. So, what do you mean by individual? What situation? The administration? Now, concerning Ms. Chang's points, we would like to respond. Now, one point we need to clarify. Why we put the bill through, we want to encourage sincere apologies so that the parties can reach a resolution as quickly as possible. But we don't want to try to achieve the objective at any cost. We don't want to deprive someone of proper justice. This is a very important principle. We don't try to help any party in a matter that occurs. So we want to strike a balance. We want to encourage people to apologize. At the same time, we want to protect the affected person so that he can achieve justice. We have to consider, we have considered many factors before coming up with our proposals. In particular, we are very concerned that if the bill says that there is absolute protection, even if just one exception is mentioned, then would there be abuse of this absolute protection? Would someone put all prejudicial evidence in one apology so that the victim would not be able to seek legal proceedings? Now, every bill must also be consistent with the Constitution. It must not break the Civil Rights Bill of Civil Rights Ordinance. Now, if we don't want to make the wording too strict, if the court has to be given some discretion to make a decision for the sake of public interest. In that case, it would be against the Constitution and it would be against the Bill of Rights Ordinance.
So, we endeavor to strike a balance with this proposal. I hope the members will consider it. Dr. N. Zhang, well, individual, what does it mean? This has not been answered. Right, time has caught up with us. It is 6:30, time to bring the meeting to a close. I saw some hands. Let me put this to members. Shall we extend the meeting by 15 minutes? Only 15 minutes? Any objection? I do. I object. All right, let me put it this way. Dr. N. Zhang, I know that you have further questions to put to the administration. If I extend this by 15 minutes, you're going to have another go at the bill. Mr. Kenneth Leung and Mr. Dennis Kwok. I'll let you have another round each. Dr. N. Zhang, you'd like to go first? Chairman, my question has not been answered. The decision maker can be court, tribunal, arbitrator, a body, or individual. What does it mean by individual? I'd like to clarify on this. A body, is it the Institute of Accountants or the Medical Council, or what body are you referring to? Mr. Kenneth Leung, Chairman. I'd like to offer some help regarding the definition of decision maker. If you may refer to the English version. Dr. Zhang, I hope that I can be of assistance. There's, in relation to applicable proceedings, you can't look at this in vacuum. We did have a fair amount of discussion about the meaning of applicable proceedings, judicial, arbitral, administrative proceedings, and so on. The decision-making. And let me just finish. Dr. Zhang, Mr. Leung. Dr. Zhang may have a question. I am awaiting a reply from the administration. I understood. That's very simple. You don't have to go into all this detail. Mr. Leung, please. Before I call upon the administration. Court, tribunal, arbitrator, any other body or individual, Chairman, you have a legal background, you have the legal expertise, you must be aware that other body or individual actually refer to the judicial, arbitral, and administrative proceedings. So this is the enactment that we look at when we look at this bill. So we are talking about the arbiters and tribunal and certain body. We're not talking about any body. There is the proceedings, the regulatory proceedings. Dr. N. Zheng, you might say that we haven't got an exhaustive list of everything, but the administration has done its best when it comes to the definition of decision maker. To have a more comprehensive interpretation, I think I can find this acceptable. That's my view of the decision maker. Dr. N. Zheng asked for a response from the administration regarding decision maker, please. Chairman, it's very simple. Individual here, any other body or individual. Now, if you can't answer me, fine. What about individual? Who can become the decision maker? We did have some discussion at the AJLS panel, and we talked about judges, and we seem to be covering more and more. Now we are covering individual. Can you be more specific about individual? Administration? Chairman. Thanks very much, Mr. Leung, for the elaboration. We basically go along with Mr. Leung. Let me say this once again. This bill applies to different situations. It includes the judicial, arbitral, administrative, disciplinary, and regulatory proceedings. In these different proceedings, the decision maker can be an individual appointed to be the decision maker, or it can be more than one person. It can be 3 individuals. They are appointed to become a body to be the decision maker. Here we are making it clear that when we are referring to decision maker, we are talking about all the individuals that can make decision. It doesn't matter whether it is an individual that is appointed or 2 or more than 2 that are appointed. These are within the definition of decision makers. Mr. Dennis Kwok, did you raise your hand? I'm in the queue, Chairman. I'm not done yet, Chairman. Dr. N. Zheng. Let's let Dennis, Mr. Kwok take the floor. I've been waiting for a long time. Dr. Zheng. Why don't you limit the time, Chairman, so we know where we stand? I just put a question, Chairman. I spent only 50 seconds. Mr. Kenneth Leung jumped in. It's like a race. Well, we are all concerned about the clauses. I'd like to give members as much time as possible. Dr. Zheng, please rest assured. I'll go straight back to you after Mr. Kwok. I know you've got other concerns that you'd like to articulate. We are going to have sufficient time. Please rest assured. Mr. Kwok? Chairman, thanks very much for the opportunity. This bill is very straightforward in itself, and it is not complicated. I remember we did scrutinize some blue bills this thick, and we didn't have as much time for them. Remember the financial resolution bill, the blue bills this thick, and we got through that very, very quickly, and we didn't go round and round in a circle, and they've answered 10 times what more to expect from the administration. In A2, the administration has already made some refinements. Mr. Michael Tin and other members have already spoken on this, and this is just about right. Well, I'd like to say again that A2A, we have to consider the factors that quite sufficient. I think the principle is to avoid any injustice. If the law is so rigid that it would give rise to injustice, then it might be liable to be challenged. I don't think we should make it too rigid in the law drafting. Now, there is a reference to decision maker and the definition of it. The bill is very clear. Decision maker, he may reach a verdict which is wrong, which hasn't had any regard to public interest or the interest of administration of justice, and he allows the statement of fact and apology to become evidence. These may be subject to challenge. This may be subject to judicial review to ascertain whether the decision is correct or not. So we do have these safeguards, appeal, JR, and it would be quite clear that the members of the public will not, because of this bill, be just subject to injustice. As chairman, I'd like to let members know about this. In the committee, we may have diverse views from around the table. Mr. or Dr. N. Zhang spent quite a bit of time going through the bill herself, and there are some doubts that she raised. And indeed, from the public point of view, the bill may not be readily comprehensible to the public. I think she is putting all these questions from the public's point of view. If we stop her asking, then it will not be fair. So I try to give her as much chance as possible to articulate her points. It is about time to bring this to a close. Now, for clause number 8, I think we have sufficient discussion. When we next meet, I hope that for clause 8, we can come to some sort of a consensus. We should have some common ground regarding clause number 8. I think at the next meeting, if we can resolve the problems in clause number 8, and we scrutinize the rest of the bill, then the Bills Committee will accomplish its tasks. Now, if this is the right way forward, in your opinion, then I hope that we can come back at the next meeting and have further discussion on 8.2 to see whether we can forge any common ground there. Dr. Zhang, finally, do you have anything else to add before we bring this to a close? Chairman, I'd just like to say from the bottom of my heart that we sit on a lot of bills committees. We've done a lot of work, and in some bills committees they can get the job done within a single day. Mr. Dennis Kwok referred to the financial bill that is this thick, and we got through that in no time. Now that's different, Chairman. The financial matters, there are many businessmen that show concerns before it came to the council. But this apology bill, once enacted, will apply to all civil proceedings. And this is about civil cases. This will be proceedings between members of the public, and there will be a lot of controversy if we do not get the issues cleared up. If you want to include the statement of fact, then there will be nobody who is prepared to make apology. It's like a collision between two vehicles. One party would say sorry, but after watching the clips, you might find out who crashed the vehicle first. Now, if this is the case, then nobody would say anything. They just get out of the vehicle. Nobody would bother making an apology. They would be staring at each other because they're worried that they may get themselves into trouble if they offer an apology.
Now, a friend asked me, he was in the restaurant business. Now, hot water was inadvertently poured onto a client. In the past, the waiter might apologize. In fact, the client might have bumped into him. Now, in the past, they would say, sorry. But now you have legislation saying that if someone says sorry, and if he says a couple more sentences, and then they might be vulnerable. It might be submitted as evidence because nobody dares to say anything for fear that he might be sued. So will you be helping to achieve social harmony? I think you are causing more strife. Nobody would say sorry. Some doctors tell me if he sees a patient being sick, he would explain in detail. In the future, he wouldn't, because it applies to everything. So concerning Clause 8, Chairman, I have grave reservations. I hope this bill would be plausible and work out. I think you want this bill to be benevolent. It wouldn't be a harmful piece of legislation. I hope your intent will be realized. I can't go against my conscience. Thank you. We all understand the situation now. AOB now. Our next meeting is scheduled to be 19th of June, 8:30 a.m. I call upon members to be present at the next meeting because we would be making a final decision on Clause 8, and after making a decision on 8.2, I think the other remaining clauses wouldn't be difficult, so we would conclude the scrutiny. If there's no other AOB, the meeting is closed. Thank you.